Yes, good morning, ladies and gentlemen. Wind's been slightly taken out myself by that introduction, especially the reference to Leeds United. As has been said, my name is John Grant. I'm a director of Goodman Grant Solicitors. We are specialist dental lawyers with offices in Leeds, Liverpool and London. We have at the moment, although it's growing literally, it seems almost by the month, something like 15 fee earners, solicitors and paralegals who dedicate their lives to dealing with the legal needs of the dental industry. And whilst, of course, size does count for nothing in many circumstances, between the solicitors alone we have approaching 100 years' experience in dealing with the dental industry, the consequence of which is that there's pretty much no situation that we have not come across over the past 15, 20, or in my case 25 years. First thing to say before I move on is that I am aware, because I'm follically challenged, that sometimes the light does bounce down off these lights and does cause a glare in the audience. So if this is a problem, please do let me know, and I've brought my hat with me so as to alleviate that particular situation. What I'm talking about this morning is the ability of NHS orthodontists to realise the goodwill value of their practices. In other words, to sell your practice. And in giving this speech, I am not making any value judgments about the issues that we come across when dealing with the NHS, when dealing with the LATs and the problems that we have. That is a matter for you, that's not a matter for me, and I'm certain that you're more than capable yourselves of forming your own judgments based on your own experiences and certainly on the basis of what you hear from me this morning. So, I think the situation can quite easily be divided into three different areas, or three different timescales. First, pre-2006, before the new contract came in, quite simply no problem whatsoever. You wanted to sell your practice, you sold it, not an issue. Then in 2006, we have the new NHS contracts that came in, PDS and GDS. There was nothing, and there is nothing, to stop a GDS contract being issued to an orthodontic practice, in the same way that there's nothing to stop a PDS contract being issued to a general dental practitioner. But what seems to have happened is that the vast majority of orthodontists ended up with PDS contracts, and I'm really by no means certain of the advice that was given at that stage or of the understanding that orthodontists had of the consequences of accepting a PDS contract, which have become patently clear over the years since then. Second thing that happened in 2006, again, as I'm sure that a significant number of you will be aware, is that there was a change to the Dentists Act which enabled practices to be owned by limited companies or practitioners to trade through limited companies. And what that meant was the assets of the practice being transferred to the limited company so that the limited company then owned the goodwill, owned the equipment, engaged the staff, and the principal owned the shares in the limited company. And as it happens in terms of the sale of orthodontic practices, that is a change which has become extremely important. Now, with the new NHS contracts, and it didn't matter for these purposes whether it's PDS or GDS, Clause 12 of those contracts says, in terms, thou shalt not sell. So on the face of it, it doesn't matter what kind of an NHS contract you've got, you can't sell it, you cannot sell your practice. But as I'm sure all of you know, the reality of the situation is that notwithstanding that clause since 2006, both PDS and GDS practices have been bought and sold quite merrily, and indeed I think it is fair to say at the moment our experience is the market has never been hotter. There are far more buyers than sellers, and it really for these purposes quite frankly does not matter whether you're talking PDS or GDS, whether you're talking general or ortho. The prices which are being commanded are significant, so the money that's involved, particularly perhaps with an orthodontic practice, you're talking hundreds of thousands of pounds, and therefore the question of whether or not you can sell your practice is something which is of fundamental importance to orthodontic practitioners, particularly, of course, those who might be thinking about retirement. There are two key differences, however, between PDS and GDS, and again, I'm sure I'm not saying anything that you're not already aware of, but for the purposes of this talk, I hope that you don't mind me repeating them. Two key differences are, in a GDS contract, you have the right to bring another dentist or dental care professional into partnership. In PDS, there is no equivalent right. Although it's also right to say that there is no regulatory reason why a PDS contract cannot be issued to more than one practitioner. But what happened as a result of the inclusion of the ability to bring in partners in the GDS contract is what was born was what became known as the partnership method of sale. Very simply, seller brings buyer into partnership and then a couple of months after the sale has been completed, retires from that partnership. And that is tried and tested and has happened hundreds, if not thousands of times since 2006. The other issue, and the other difference, the key difference from this point of view, is that PDS are time limited. And again, just to emphasize, because it did come as a shock to some practitioners when their contracts were up for review, it is right to say that there is no obligation whatsoever on NHS England to renew any orthodontic or general or PDS contract. So they can simply turn around at the end of the term and say, sorry, you're not getting another one. And as I say, that certainly came as a shock to some of my clients. The other key difference is that if you have a PDS contract, then with regard to general dental services, you have the right to transfer from PDS to GDS. And clearly then once you've got a GDS contract, you can make use of the partnership route and you can sell your practice. But that right only applies to general dental services. It does not apply to orthodontic services. And therefore, on the face of it, since 2006, the position has been that we couldn't use the partnership route. You had a time-limited contract. You couldn't transfer from PDS to GDS, and therefore, you could not sell your practice. Between 2006 and 2013, it is fair to say that in the vast majority of cases, by one means or another, we managed to facilitate a situation whereby our orthodontic clients were able to sell their contracts. Now again, and one of the things that I'm going to come back to a number of times, one of the issues that we faced, and that we still face, and in fact has just been alluded to, is that it seemed that every PCT around the country had a different attitude to these things. And not only that, but the same PCT could have a different attitude if there was a new contract manager appointed. And it would perhaps be not stretching the point to say, and the contract manager's attitude might sometimes change depending on what side of the bed he got out of that morning. So it was an interesting time. But as I say, the reality is that between 2006 and 2013, in every case that we handled, we were able, by negotiation and discussion with the LAT, or PCTs as they then were, to find a way for our orthodontic clients to sell their practices. And then we come to the reorganisation in 2013, and the situation that we are in now. And the primary change, and I was interested to listen to my predecessor speaker about the issues, which I absolutely understand the NHS face. But the key, my understanding of the key change in 2013 was that instead of all of these PCTs all around the country doing their own thing, that there was one organisation, NHS England, represented around the country by LATs for organisational purposes, but that what we were going to get was, if not entire consistency, then certainly a far greater degree of consistency between the LATs than we'd had between the PCTs. when it came to dealing with these issues. Again, as I'm not making any value judgment, but the fact is that whilst there are fewer of them, it is the case that every LAT around the country seems to have a completely different attitude to the issues that need to be considered, which I'm going to come on to in a moment when talking about the sale of an orthodontic contract. So from that point of view, I'm afraid that I'm in no better position to advise any of you individually today whether you are likely to be able to sell your practice than I was pre-April 2013. At the moment, we have LATs who, if their orthodontists approach them and say that they would like to sell their practice, they say, well, why don't you incorporate? And then you can sell. We have other LATs, had an orthodontic practice, which we completed in August, where the LAT had already added my client who was buying the practice, and she was an associate at the practice at the time. They had already added her to the PDS contract as a signatory. Now, being a blunt Yorkshireman, I've no idea what the hell that means. It sure as hell doesn't mean anything from a legal point of view, but she was added as a signatory, and as it transpired, that enabled us to sell the practice by simply the seller retiring from the contract. It would be fair to say that, therefore, you may be lucky enough to be within the area of one of the LATs that says, if you want to sell, go ahead and incorporate. But most LATs are, quite frankly, not so accommodating. And that means that if you want to sell your practice, you have no choice other than to incorporate, because there's no right in your contract to sell. So what you do is you transfer the contract to a limited company. That limited company then owns the goodwill, it owns the equipment, etc., as I've explained previously. And then what you do is you sell the shares in that limited company. And the sale of those shares does not of itself in any way contravene the terms of your contract. Simple. Of course it isn't. Because the other thing that happened then in April of 2013 was that NHS England issued its guidance on the incorporation of NHS contracts. And again, this really was one area where pre-2013, every PCT had a different attitude to incorporation. Some were quite happy, a lot weren't. Some would demand a reduction in UDA rates. And it really was an area where we were hoping that there was going to be a greater unity, greater conformity, if people wanted to incorporate. But that's not the case. If you look at the NHS guidance on incorporation, one of the first things that it says is that if you want to incorporate, you have to demonstrate to the LAT what will be the benefit to the LAT and stroke or to patients of the LAT allowing you to incorporate. Again, the reality is, quite frankly, that there is no benefit. This is being done to enable you to sell your practice, or it used to be done until the recent changes in the legislation for tax purposes. But to say that it was for the benefit of the LAT or for patients was somewhat tongue-in-cheek, to put it mildly. But the problem with demonstrating benefit is that although the guidance says that you have to demonstrate benefit, there is no guidance whatsoever on what benefit means. And therefore we are in a situation where we're having to rely on the individual LATs to tell us what they are going to determine benefit to mean, which in turn, quite frankly, means that you are at their behest as to whether or not they're going to allow you to incorporate. There are some LATs, as I've said, if you go to them and ask you to sell, they will say, go ahead and incorporate, and with them, quite frankly, you really don't have to show anything at all. The pattern that does seem to be emerging, however, is that the most common benefit that LATs are looking for is an increase in hours. Opening on Saturdays, opening later during the week, particularly to facilitate school children attending. So one of the things that I would say to you is that if you want to sell your practice, be prepared to open longer. So assuming then that you can demonstrate a benefit, does that mean that that's the end of the story? Again, I'm sorry, but of course the answer is no. Because if the LAT does allow you to incorporate, then what they will produce is what we call a deed of novation, which, again, in plain speak, simply means that is the document by which the contract is transferred from you to the limited company. And that document of itself raises a further two issues that you need to be aware of. The first is that you will be required, as an individual practitioner, to continue to personally guarantee the performance of that contract to the LAT. That is actually perfectly fair and reasonable, because that is the position that you are in at the moment before you've transferred the assets to the limited company. And again, from a legal point of view, one of the big benefits of trading as a limited company is that you have what we call limited liability. So in other words, if the company does not have the money, creditors cannot come after you personally. So if the contract was not performed and the limited company did not have the money, then the LAT would not be required, could not come after you personally to recoup that money. But as I say, my view is that that's perfectly fair and reasonable, because the requirement for a guarantee only places you in exactly the same position as you are at the moment anyhow. The problem with the way in which the deed has been drafted, however, means that that guarantee would continue even after you have sold the shares in the limited company. And that's clearly something which is quite unacceptable. That is placing you in a worse position. That is placing you in a position whereby you'll continue to be responsible for the performance of that contract, even after you've no involvement in the practice whatsoever. Now, on that front, one of my colleagues took High Court proceedings for what we call judicial review against NHS England, and NHS England, outside the doors of the court, agreed to settle on the basis that they would back down on that point. So again, my advice to you is that if you're going down this route and the standard deed of novation comes out, you should be able to go back to them, as I did on behalf of a client on Thursday of last week, and say, everything's fine, but I'm sorry, we can't have this particular clause in. I don't mind you guaranteeing the contract for as long as we have the shares, but once we have sold the shares, then I'm sorry, that liability must pass to my predecessor. The second issue in the deed of novation is the insertion of what is called a change of control clause. And this really is where things do get very tricky, because a change of control clause says, if you intend to transfer more than 10% of your shareholding in the company, then the LAT has the right to terminate the contract. In other words, the LAT has the right to block a sale, and you have lost the goodwill value of your contract. And as I say, these days we're, in pretty much every case, talking about hundreds of thousands of pounds. What the guidance goes on to say is that the LAT cannot unreasonably refuse consent. But again, there's no guidance on what may or may not be considered reasonable, and you can be sure that every LAT up and down the country is going to interpret reasonable differently. What I would say is that if you're planning to dispose of your practice, particularly to somebody who's on the specialist orthodontic register, I think it's going to be very difficult for an LAT in those circumstances to refuse. The problem is that there are some LATs who have been and continue to be what I would only describe as notoriously difficult, who may take this as an opportunity to turn around and say no. And if they do say no, then your option, should you wish to try and realise the goodwill value of your practice, is to take what we call judicial review proceedings in the High Court. Every public authority has an obligation to behave reasonably. And if it is your view that they are not behaving reasonably, then you have the right to take them to a High Court for a declaration. That's all well and good, but the problem is that being a lawyer, I am never going to guarantee with anybody what the outcome of any court proceedings is going to be. I always say if I could guarantee with any degree of certainty what the outcome of court cases was, I wouldn't be stood here, I would be on my island in the Caribbean sipping from my G&T. The reality is it ain't like that. So you're faced with uncertainty and the fact that these proceedings are extremely expensive. You are talking tens of thousands of pounds. So that may or may not be viable for you depending on your situation at the time. The situation at the moment, however, is that orthodontic practices are being sold. I would say that on average we're completing in our practice alone probably one a month. Typically you will get an upfront payment for the value of the contract until the contract is due to expire, and increasingly we're then seeing deferred payments if the contract is renewed. We are able to negotiate and correspond and discuss matters with the LATs. And thus far, I'm very pleased to report that all of our clients have been able to sell their practices with one exception, where the LAT were not willing to accept his proposals as to what constitutes the benefit of his practice. In summary, I would say that, as I hope you've gathered, the position is complex. The fact is that we are still dependent, or you are dependent, if you wish to sell your practice, upon the goodwill of your LAT. And my message to you, if you take nothing else away from this, is please be nice to your LAT. If you treat them like the enemy, then you're likely to get the same back. The third thing that I would say, and again I would hope it's obvious from what I've said already, is that this has become a very specialist area. And whether you engage myself or one of my other professional colleagues from around the country, you do need a specialist dental lawyer if you intend to sell your orthodontic practice. Ladies and gentlemen, I hope that provided you with some useful information, and I hope you enjoy the rest of the conference. Thank you very much.